Did we get everyone?
Thank you. So we are back. Senate Judiciary, we're taking up page 89 now, and we're starting with Renee McGinnis, who is a member from the Vermont Family Alliance.
Oh, hi. May I screen share?
Yes.
I'll introduce myself first. My name, hi. Thank you for taking the time to receive our testimony today. My name is Renee McGinnis. I am a member of Vermont Family Alliance. I presented concerns on both H89 and S37 companion bills. Actually, let me screen share here. My document. Yeah. There we go. I have presented concerns on both S37 and H89 to committees. Both bills serve to protect gender affirming model over other models that might better serve those experiencing gender dysphoria and incongruence. In my testimony today, I hope to lay out the reasons why both H89 and S37 fail to protect minors, youth, and families. First of all, number one, mental health and suicidality. Proponents believe they are shielding best practice care, improving mental health, and reducing suicidality. The Trevor Project is the only evidence-based resource provided under H89 witness testimony, which is a survey, not a study. There is no evidence-based studies on the Trevor Project website that conclude gender affirming care saves lives and improves mental health. One of the studies from the Journal of Adolescent Health referenced on the Trevor Project website states there are no large-scale studies examining mental health among transgender and non-binary youth who receive gender-affirming hormone therapy. A 2011 study out of Sweden concluded persons having received sex reassignment have considerably higher risks of psychiatric morbidity, suicidality, and mortality than the general population. When questioned by House Judiciary Committee members on comparative data on suicidality in states that affirm versus states that ban or limit gender affirming care, both Dr. Erica Gibson and Polly Kozier provided anecdotal evidence and speculation on future data. Neither followed up with evidence-based data on mental health and suicidality, either independent of states or based upon comparisons of states' stances. Anecdotal statements about parents' fears for their children's emotional well-being were accepted as legitimate evidence. Dr. Gibson stated she does not have collated data based upon the types of care patients are receiving through the UVM Medical Center Children's Transgender Youth Program. On April 4th, Dr. Gibson claimed before the House Committee on Healthcare that whatever resources a patient needs are made available to them, yet the link she provides on her written testimony titled Transgender Youth Program assumes a transgender diagnosis. And if this website is considered the hub for gender dysphoria resources in Vermont, information on the universal experience of uncomfortableness among adolescents during the process of puberty is missing. I shared that link again here for you. Vermont prohibited female genital mutilation in 2020, yet vaginoplasty, orchiectomy, and phalloplasty are not considered mutilation. I see a contradiction there. 3, childhood trauma is the underlying cause of poor mental health. An AAP study, American Academy of Pediatrics study, indicates childhood trauma as the underlying cause of anxiety and depression, which needs to be addressed with restorative psychiatric therapy, not gender affirming care. 4, international standards of care. Here's a link to Quick Facts, a digital booklet. It's 8 pages on the side effects, complications from hormones and surgeries, and international status of gender affirming care. The booklet is from the website sexchangeregret.com, founded by Walt Heyer, a man who suffered childhood trauma, transitioned to a woman and back again. He has received 2 million visitors to his website and 10,000 plus emails from people who regret their transition. Pages 2 and 3 of the booklet provide the status of on international standards of care. The UK, Sweden, Norway, Finland, and France have all taken steps to protect children from hormones and surgery. And I invite you to check out the research and voices options under the posts tab on Walt Heyer's website, sexchangeregret.com. Jessa Barnard, the executive director of Vermont Medical Society, stated February 7th before the House Committee on Judiciary that there are national and international standards of gender affirming care. The World Professional Association of Transgender Health standards are not necessarily, they're not being followed in Europe. Clearly, there's a conflict nationally, whether national standards of care are ethical. Vermont is taking a position at odds with recent studies and will perhaps find itself on the wrong side of history regarding gender affirming care that you intend to shield with these bills. The CAS review interim report on Tavistock Gender Clinic. I presented this, the summary portion of this study that came out in February of 2022 out of the UK. It's an ongoing study. The standards of care are rapidly changing. That study found that the practitioners felt pressured to comply with gender affirming practices that go against clinical assessment and diagnosis practices. Control measures were lacking, and there is no conclusive evidence on the use of puberty blockers and cross-sex hormones. And I also recall that the case mix has changed. Historically, gender dysphoria has been found among birth registered males at a very young age. The case mix is now there's a lot of adolescent birth registered females in adolescence presenting with gender dysphoria. That's a change in the case mix that needs to be questioned and asked, why is this happening? Yet they're just kind of moving forward and treating everybody with the same way. 6, puberty blockers, cross-sex hormones, gender assignment surgery. Most common are urological complications from bottom surgeries on both males and females. Some studies indicate 25 to 40% urological complications. Urine leakage out of unwanted openings and urine blockage are common, possibly leading to kidney inflammation if left untreated. Puberty blockers, some of the side effects are failure to grow, liver damage, mental health problems, skeletal damage, bone thinning, infertility, osteoporosis, and cardiovascular disease, brain swelling, vision loss. Puberty the process of puberty is what helps us human beings develop healthy brains and bodies. So the effect of disrupting puberty are not known. C, cross-sex hormones for females taking testosterone, heart attacks, strokes, liver dysfunction, type 2 diabetes, for males taking estrogen, blood clots, heart attacks, strokes, breast cancer, weight gain, insulin resistance, gender assignment surgery. 50% of birth registered males experience complications, pain, surgical site bleeding, urinary dysfunction, sexual dysfunction. For birth registered females, hysterectomy, of course, causes sterility. The suicide rate is 19 times higher 10 years after surgery. Again, I refer you to Walt Heyer's sexchangeregret.com. Check out his research tab. So the question is this the standard of care? Given all these side effects and complications, is this the standard of care that will be shielded under H87 and H89 and S37? And if so, what's considered medical malpractice? 7, consequences of S37 and H89. So H89 shields exclusively gender affirming practitioners from abusive litigation, leaving practitioners who do not follow gender affirming standards of care at risk of being investigated or losing their license. When doctors have no choice, patients have no choice, parents have no choice. H89 may even shield practitioners from lawsuits when there is actual negligence, because the risk of losing a lawsuit and countersuit under abusive litigation is overly burdensome in many ways, not just financially. Although gender affirming care could be considered outright criminal, not just negligent, given the side effects, complications, and lifetime damage, both mentally and physically. S37 requires insurance companies to cover gender affirming care without limits and shields gender affirming care practitioners from increases in medical malpractice premiums, protecting them financially from the types of lawsuits filed internationally and nationally by minor aged patients who claim they were rushed or pressured into gender affirming care along with their parents and denied informed consent on the side effects of puberty blockers and cross-sex hormones and complications from gender assignment surgeries. So Vermont Family Alliance, we are very well aware that there is no explicit language in either H89 or S37 regarding parental rights and minor consent. We are asking you to consider whether the care you would be shielding that I just went over is helpful or harmful to minors, youth, and their families. Thank you.
Thank you. Renee, I just have a quick question, and I don't want to jump to conclusions. I just want to make sure I'm understanding. You mentioned that doctors who don't follow the standards of gender affirming care are at risk of being investigated and losing their licenses. And I was wondering if you could expand on that a little bit, because in my opinion, any doctor who deviates from their standard of care, they probably should be investigated if they're not doing their job properly. But I might also be misunderstanding something. So I was just hoping if you could expand on that a bit.
Well, if gender affirming care is the only standard of care, what I'm saying is I would like you to look at whether or not that is actually healthcare. I just presented you with all the side effects and complications and whether or not that's helpful or harmful to youth and minors. And there doesn't seem to be, along the way, things have been restricted. I think Carol will cover that in her testimony, and I don't want to cut into her time. So her testimony will probably answer your question, I believe, more fully. There's also, yeah.
All right, any other questions?
This is actually probably a question for legislative counsel, but I would just, or maybe given that you're studying for the bar, you can answer the question. I love a sort of just overview of like what qualifies as abusive litigation.
Like ledge counsel.
Yeah, it's kind of what I thought.
Good morning.
Oh, hi, Michelle.
Hi. So there is language in H89, and I can go over it with you at some point this morning if you have time after the witnesses, that define specifically abusive litigation. And let me look at this and I can point you to the section.
I see it.
Yep. So if you look at page I'm looking at the Senate version. So if you look at page 3, section 3, and you'll see there, so abusive litigation means litigation or other legal action to deter, prevent, sanction, or punish any person engaging in legally protected healthcare activity. And then you go back to the definition of legally protected healthcare activity, which, as I mentioned during my walkthrough, we're going to adopt the definitions from what the Senate passed in S37 because we just tweaked it a little bit, but it's essentially the same concept as what you have and what passed in the House bill. Basically, it's that if somebody is going to be engaging in legally protected healthcare that is legal here, and the provider is licensed here, and they are physically present here and they are providing that health care. If there is litigation from outside the state that's looking to deter people from accessing legally protected health care, then that would be considered abusive litigation.
Thanks for just helping me clarify that. But I guess I'm also trying to make the connection in how deciding that you aren't qualified or engaging in a certain type of healthcare, how that would even apply. Like, you can't be sued for saying, well, that's not the kind of doctor that I am, You can't, I guess what I'm saying is like, provided you are not negligently not giving someone care, you can't be sued for not doing something.
Is that a question for me or the witness?
No, I think it's a question for you.
Okay, I guess I'm not quite understanding.
So if I'm a pediatrician and I do not offer gender affirming care, I can't be sued for that.
Correct.
I'm similarly trying to understand, I think, Senator Hashim's question, just like trying to make the connection. So thank you for just helping me clarify.
Right. I mean, I also want to point out that there are a few places in H89 that explicitly say that if conduct is actionable here in Vermont, you know, it's not considered abusive litigation. So in the case of someone who, let's say, does provide gender affirming care, is licensed to do so, is following the standards of practice, you know, and then they are protected. But if they engage in deviating from the standards of practice, if they engage in negligent provision of healthcare services, things like that, things that would be actionable for like a med mal suit here in Vermont, this bill doesn't prohibit that at all. I think, and I don't want to put words in the mouth of the witness, but I think what I heard her saying was that that because Vermont accepts the standards of care around gender affirming care, that then and gives protection to that, then they don't have the ability to sue and challenge that that's medical malpractice, I think. But I
That's
guess
not really changed in this bill. Like already someone in Vermont couldn't sue for that because we've accepted that as the standard of care.
right.
Okay, thank you. I was just trying to wrap my head around it. So thank you for helping me understand the legal landscape.
Sure.
Thank you, Michelle. Next witness is Carol Kaufman.
I got a quick
Oh,
question.
sorry. Senator Norris has a question. Sorry, Michelle.
Are you there, Michelle?
Yep.
Quick question. Someone seeking gender affirming care, is there or is there not an age requirement on this? Or parental consent?
I think there is, so minors cannot consent without their parents. I'd have to go back and look. This has been the issue around parental consent to healthcare, things like that has all been dealt with Jen and Ameren and the healthcare committees, but I do have that information, but I would have to take a peek and look at that. But generally minors cannot, unless specifically exempted or addressed in the law, minors cannot consent.
At what age? We're talking about 22, 21, 20, 18, or what are we talking about?
Under 18 is considered a minor.
Well, I realize that, but depending on which bill we're looking at, it goes up to age 22 as far as where they're being prosecuted and so on and so forth. We seem to have a moving targets goalpost here.
Well, generally, when we're talking about, when we use the term minor, we do, I mean, maybe it gets used in other contexts and defined separately, but in general, like in our Title I definitions, minor means someone under 18, someone who is not emancipated and is under the age of 18.
Okay, I would like that information if in fact you do have time to find it, Michelle.
Did Ameren already come? I couldn't remember. I thought she was scheduled with you guys, but did she get scheduled and then bumped off the schedule on this? I think you were going to have her in, or am I mistaken?
You already have her? Thought we had her. We'll double check.
I'll email you the information that was presented by Ameren and Jen in the healthcare committees on consent. Okay.
Thank you.
Sure.
Okay, next witness is Carol Kaufman.
So minors 18 under juveniles, 22 and under.
Carol, are you with us?
I am.
Awesome.
I'm pushing
The floor is
buttons.
yours.
I got the mute. Oh, there we go. Okay. Hello.
Hello.
Okay. So thank you for this time. My name is Carol Kaufman. I'm with the Vermont Family Alliance, an advocacy group for parental rights and responsibilities and minor protections. H89, the so-called Shield Bill, will constrict Article 22's personal reproductive liberty without voter approval or a day in court. Companion bills S37 and H89 will protect a one-direction model of care for a minor child who may be experiencing gender dysphoria, therefore interfering in the Vermont state constitutional right to reproductive liberty. H89, S37, the so-called shield bills, do not extend equal personal reproductive protection as required under Article 22. Prior to the November vote, proponents publicly stated that Article 22 will make it difficult for future legislators to interfere with personal reproductive liberty. H89, by exclusively protecting, I skipped too quick, the one direction gender affirming healthcare model and prohibiting so-called conversion therapy, are government interference and loss of reproductive liberty choices because patients are denied information about a care model that could allow them to resolve their dysphoria without damaging their fertility and bodies. 18 VSA A 8351 prohibits so-called conversion therapy and is codified in Act 35, H89, and S37. The Vermont government has prohibited a model of care that believes children are best served by helping them align their gender identity with their anatomic sex, because the vast majority of childhood gender dysphoria cases resolve by the time the child reaches adulthood, with the patient's self-perception reverting back to align with their biological sex. Each committee member must consider today's exponential suicide rate within the gender dysphoric demographic. If suicide is the result of the absence of the one direction gender affirming healthcare model, then why doesn't history show mysterious exponential youth suicide rates when today's gender affirming model was not an option of care and when the now prohibited conversion therapy was the mainstream model of care? Vermont Family Alliance would like to bring in balanced expert testimony regarding other care models for gender health care protected under Article 22. For national examples, feminist Deborah So, sex neuroscientist, author of The End of Gender, Debunking the Myth about Sex and Identity in Our Society. Then there's Nancy Piercy, author of Love Thy Body. And Dr. Susan and Marcus Evans, authors of Gender Dysphoria, a therapeutic model for working with children, adolescents, and young adults. Marcus Evans stated, quote, "It's another matter to start interfering with a healthy body. One would want to think very carefully before you do that. I have submitted testimonials from individuals describing their experiences as fast-tracked. Even though they are not from Vermont, their care was exclusively gender affirming, and I believe each of them have lawsuits claiming lack of informed consent and permanent damages. I hope you'll read each of them. Prisha Mosley decided to stop her medical transition. Quote, "No doctors will help me fix this, and insurance is paying for nothing. Will H89 protect minors and adults wanting to detransition to their biological sex? And will insurance cover all mental and medical treatment needed?" Consider one of the national cases of Chloe Cole, who is suing Kaiser Permanente of California. In Chloe Cole's lawsuit, the defendants falsely informed Chloe and her parents that Chloe's gender dysphoria would not resolve unless Chloe socially and medically transitioned to appear more like a male. Quote, the vast majority of childhood gender dysphoria cases resolve by the time the child reaches adulthood, with the patient's self-perception reverting back to align with their biological sex. Under Chloe's One Direction gender-affirming model of care, quote, between 13 to 17 years old, Chloe underwent harmful transgender treatment, specifically puberty blockers, off-label cross-sex hormone treatment, and a double mastectomy. Chloe believed she was allowed to make an adult decision as a child. We should be able to agree that children do not have the physical and emotional or mental capacity to protect themselves or to make life-altering decisions with or without their parents. Vermont state government has age restrictions for drinking, alcohol, driving, gun ownership, smoking, and marijuana with or without parent consent because of brain development. For the same reason, age restrictions must be considered for age 89. Standards of care are changing rapidly, and parents' rights to direct the care of their children need to be protected in law. Age 89 expert testimony must address minor brain development, informed consent, minor consent challenges, minor protections, such as case plans, due process, and court oversight. Parents must be free to find the individual healthcare, transparency, and information that is necessary for them to direct the medical treatment that is best for their minor child beyond the One Direction gender-affirming model of care, and government must not interfere. Vermont Family Alliance agrees that H89 does not change consent for minors, and it does not restrict parental rights. Yet, the standard of care can change the day after H89 becomes law. Also, parents have lost their right to direct their child's reproductive care prior to age 89. Act 35 of 2017, quote, this bill proposes to allow minors to consent to mental health treatment for any condition relating to the minor's sexual orientation or gender identity without parental knowledge. Under Act 35, parents are not able to select the most appropriate counselor for their children. Title 16, 132 requires, quote, at a minimum, condoms shall be placed in locations that are safe and readily accessible to students, including the school nurse's office. Again, parents are not involved and have no input over adult access to their children. Parents are reporting gender ideology influences within growing lawsuits in their child's public school at an early age with books, curricula, and counseling without their knowledge. And by the time parents are involved, their oversight is too late, as Abigail Schreier documents hundreds of families experiencing within the fast-tracked gender-affirming model of care in her book, Irreversible Damage, The Transgender Craze Seducing Our Daughters. H89 will only protect every unknown person participating in the One Direction gender-affirming care, leaving no protection for parents and mental and medical doctors and others who do not agree. Quote, any act or omission undertaken to aid or encourage or attempt to aid or encourage any person in the exercise and enjoyment or attempt gender-affirming healthcare services secured by this state or to provide insurance coverage for such services taken from H89. This should terrify every American. I submitted an amicus brief by Dr. Erica E. Anderson, PhD, with my testimony. Dr. Anderson is a clinical psychologist practicing in Berkeley, California, with over 40 years of experience and is transgender. Dr. Anderson argues, quote, whether a minor experiencing gender incongruence would transition socially is a major and potentially life-altering decision that requires parental involvement for many reasons. Dr. Anderson details those reasons in her amicus, and Dr. Anderson's table of authorities is exhaustive. H89 Shield Law continues to expand and protect unknown adult access to children without parental, state, or court oversight. It's terrifying that Vermont legislators would actually believe that H89 is good and safe for our children. Thank you.
Thank you, Carol. And next up we have, oh, sorry, were there any questions, Carol? Oh, okay. Next up we have Sharon. Is it Toborg or
Toborg.
Toborg. Okay, thank you.
I should have sent you guys all the information about the question you had asked.
Oh, thank you.
The email that you guys.
Good morning. For the record, my name is Sharon Toborg, and I'm a policy analyst for the Vermont Right to Life Committee. Thank you for the opportunity to testify on H89. I'm sure it may come as no surprise to you that the Vermont Right to Life Committee opposes the entire premise of the bill. Abortion is not health care and should never be defined as such. But with that being said, I would just like to call your attention to two provisions of the bill that I think are particularly concerning. First, H89 establishes in law lower standards for providers of so-called legally protected health care than for providers of other types of care. H89 includes in the definition of legally protected health care, gender affirming and reproductive procedures provided in Vermont, as well as care provided by Vermont practitioners located in Vermont, even if the patient is physically located in another state. The definition reads, the provision of a healthcare service by a patient duly licensed under the laws of the state and physically present in this state shall be legally protected if the service is permitted under the laws of the state, regardless of the patient's location or whether the healthcare provider is licensed in the state where the patient is located at the time the service is rendered.
I'm sorry, Sharon, where are you looking at?
That would be, well, the first page, definitions, section 1 of the bill on the definitions. And I think this actually is the definition from S37, which we all know you're adopting.
I can also find
Yeah.
it too. I was just curious. Thank you.
Yeah, it's section 1 of the bill under subsection B for legally protected healthcare.
Thank you.
Now, you need to be aware that this proposed definition is in conflict with the Vermont Board of Medical Practice policy on the appropriate use of telemedicine technologies in the practice of medicine, which they adopted on March 1st of this year, which states, the state of Vermont and the board follow the rule on medical licensure recognized across the United States. A physician must be licensed or appropriately authorized by the medical board of the state where the patient is located. The practice of medicine occurs where the patient is located at the time that telemedicine technologies are used. Physicians who diagnose, treat, or prescribe using online service sites are engaging in the practice of medicine and must possess appropriate licensure in this jurisdiction where the patient receives care. Currently, practicing medicine in a state without being properly licensed in that state constitutes unprofessional conduct under Vermont law. S37, the companion bill to H89, proposes to carve out an exception to that standard for the providers of so-called legally protected healthcare. Under S37, what would constitute unprofessional conduct for other healthcare providers would be allowable for providers of so-called legally protected healthcare. This lowering of standards is very concerning. It sets a dangerous precedent of loosening standards for those providing politically favored services. And as S37 acknowledges, this proposed standard is less protective of the public. This provision could also undermine the state's ability to uphold other regulations on abortion providers should they be challenged under the new constitutional amendment passed in November, as it could be cited as evidence that the state finds no compelling interest in regulating abortion providers in the same manner as other providers. Vermont requires healthcare providers who treat patients through telemedicine located in Vermont to have appropriate licensing or approval or face fines and sanctions. Vermont should not protect healthcare providers who treat patients in other states in violation of those states' licensing laws. And second, H89 allows strategic lawsuits against public participation, also called SLAPP suits, to be used to punish those exercising their First Amendment rights. Strategic lawsuits against public participation, also referred to as SLAPP suits, are intended to silence, intimidate, or punish individuals exercising their First Amendment rights by burdening them with expensive and time-consuming litigation. In 2005, Vermont adopted an anti-SLAPP statute to protect individuals from these types of lawsuits by providing an expedited process to have such cases dismissed. However, Section 2 of H89 would again carve out an exception to Vermont's anti-SLAPP statute for cases involving tortious interference with legally protected healthcare, as described in the bill. Removing the protections provided by the anti-SLAPP statute for such cases can only be seen as an attack on the First Amendment rights of those who wish to speak out publicly against what would become politically favored services under H89. It will invite harassing legal action against a person for engaging in constitutionally protected speech. In addition, the vagueness of the proposed language of Section 7302 subsection A would further chill speech. I urge the committee to strike Section 2 from the bill and keep the anti-SLAPP protections in place for all Vermonters, including those who wish to exercise their First Amendment rights on issues of public interest, such as abortion, reproductive rights, and gender care. And this final thing, I'd just like to note that when Legislative Council did the walkthrough of the bill with you, that Section 2 was skipped over, and we were going to come back to it, and I think time got short and it never got addressed again. And I think that it's a very concerning section of the bill, and I hope you'll take time to look into it some more. And I'd be happy to answer any questions you might have.
I'm good.
Yeah, I'm good too. Thank you.
All right, thank you.
Senator Hashim,
Yes.
I can address the SLAPP suit section if it's helpful briefly.
That'd be great. That'd be great. Thank you.
So the Section 2, so you passed a number of years ago this provision around strategic lawsuits against public participation, and the idea was that if someone was engaging in filing frivolous lawsuits against someone to either deter or prevent or discourage someone from engaging in public participation, like a city council meeting or something like that. I think we discussed this a little bit earlier when I perhaps had discussed it in another context, is that, so if you imagine if there is a, maybe a a big developer that is looking to, develop a parcel of land in a town, and there's DRB hearings, and some local members of town are going before the DRB meeting, opposing the developer's plans. If that developer was continuously filing a number of motions and lawsuits and things against those folks and there was no basis for that, and it was essentially trying to deter them from speaking out to their government officials around that idea, then that would not be recognized. And so what this is doing, and why this provision is in here, is it's saying that what you have later on in the bill is the tortious interference with legally protected healthcare. And what that is, it allows someone who is in Vermont, who has been sued by someone outside of the state. So someone from outside the state is engaging in abusive litigation against someone here for the purpose of trying to deter them from obtaining legally protected healthcare. And then what you do in H89, it provides that person who's being sued to countersue that person. And what Section 2 does is it says the person who initiated the litigation from out of state, who is now being countersued by the Vermonter, the person out of state cannot then argue on that countersuit qualifies as a strategic lawsuit against public participation. So it's not saying, so again, it's only employed in the case where someone has initiated abusive litigation to prevent someone from either providing or obtaining legally protected healthcare. Then you have that person who was initially sued has the ability to countersue. And so the SLAPP section in Section 2 simply says that when they countersue, the person who was countersued can't argue that the countersuit is void because it's infringing on their First Amendment rights. Does that make sense?
Thank you. It does.
Okay.
Thank you, Michelle.
But that is not clear.
Well, actually, we're not gonna go back and forth between multiple witnesses, but if you want to submit some written testimony in response to that, we will read it. And we are getting short on time. We can go over by a couple of minutes, so I want to hand it over to Aubrey from Planned Parenthood.
Hi, yeah, clarifying for the record, my name is Aubrey Weaver. I know it says Audrey in the agenda, but it's Aubrey with a B. And I'm testifying on behalf of UVM Planned Parenthood Generation Action. I can definitely get through my testimony in the amount of time left in your committee hearing today. All right. So we are the student members of Planned Parenthood Generation Action at the University of Vermont. We are writing to urge our support of H89. We are a student organization with over 2,000 on-campus members and by association, 2,000 Vermont constituents. We are saddened that it has become the responsibility of groups like ours to advocate at the state level for what for 50 years was a constitutionally protected right. However, being from both Vermont and a collection of other US states, your decision on this bill is of utmost importance to our health and well-being, both when we are in Vermont pursuing our education and when we are visiting our families at home. This bill passed out of the House with a very strong vote and is now in the Senate Judiciary Committee. The bill focuses primarily on legal protections within the bounds of the United States Constitution. It would protect healthcare providers and patients from states with abortion bans and bans on gender-affirming care, who travel to Vermont for this care as doctors who provide abortion or gender-affirming care. It also includes a provision that would allow health providers to countersue if they are subject to hostile litigation. There is a provision for enhanced protections for patients and providers to safely access healthcare facilities, and a provision that expands the Secretary of State's Safe at Home mail forwarding service to providers and patients who are who are subject to security concerns over their provision to access legally protected healthcare activity. We ask you to bear in mind that in 2014, the Guttmacher Institute reported that the largest age share of individuals seeking abortions was 18 to 24 years of age, the age of college students. Now that national access to reproductive health care has been restricted in many states, a significant proportion of Vermont students can only attain this life-saving reproductive health care while in the state of Vermont. Vermont, by nature of being a small population, is unique in that a majority of UVM students, 65%, come from out of state. I encourage you to look at some maps I have attached to my testimony. I'm going to try to share my screen and show you, but it's disabled for participant screen sharing. But the gist of it is that when you view the location demographics of the UVM student population and the map where abortions are restricted across the United States, you'll see an unfortunate overlap where hundreds of UVM students are in abortion ban states as their home states. So what H89 looks like in application for us students is that if a UVM student from, say, Texas had to seek an abortion while at college in Vermont and their parents or acquaintances in Texas find out and seek to prosecute them or their Vermont provider for that action based on Texas's strict law, H89 would protect both the patient and the Vermont provider from having to involve themselves in the Texas investigation. Unfortunately, if the student returned home to Texas for an extended period, they would have to comply with that investigation while at home, be in support of amendments or future legislation looking to address this, though we understand the legal complications. I want to share some perspective on this issue from a college organization, as we know you likely don't have student witnesses often, and this is our first time testifying on H89. College is notorious for being a period of sexual experimentation for young consenting adults. Part of our role in PPGA is to offer safe sex education and supplies on campus. And while we have learned that there is nothing that will stop college students from having intercourse, it is important to make sure there are as few medical or emotional consequences as possible. I think that there's a preconceived notion that due to all of the fun college students have and the majority in favor of the right to choose, that we take the possibility of pregnancy lightly. This is not the case. There have been comments made to us by opponents of our stance that they don't want to see abortion become another form of birth control. What they don't anticipate is that we agree. Abortion is a serious medical procedure, much less than giving birth, but still significant enough that we don't wish for anyone to have one, if at all avoidable before the fact. While we think access to abortion should be open and shameless, we are by no means glorifying this practice. Sexually active individuals who aren't looking to get pregnant live in a constant anxiety cycle surrounding menstruation. I'm sure you have all heard of pregnancy scares. When a period is late or a cycle is skipped, and being in college, there isn't a person I have spoken to that doesn't know someone or has personally had this type of scare. We also know someone who has disclosed their experience with needing to seek an abortion and the opportunity provided to them not needing to care for a child before they were financially or emotionally ready. I ask you to think about the college-age students in your life, be it children, nephews, nieces, or grandchildren, and ask if you think they're ready to be parents right now. Vermont could benefit in a very tragic way from having these protections, especially for college students who are looking for where to start their adult lives. Healthcare security is important to us, and Vermont can provide that if they pass H89. In conversations with roommates and friends at UVM, I have heard an increased interest in living in Vermont post-graduation as a result of Vermont's passage of the RLA and similar healthcare protection policies. Shield law protections are so important for those of us who do want to visit home for extended periods without the risk of legal consequences for personal healthcare decisions we've made at college. We entreat you to not overlook your transient constituents. Proving to be a leader in reproductive healthcare could be the difference between transient and permanent young Vermonters. Thank you.
Thank you very much, Aubrey. Perfect timing. Any questions from you?
No, thank you for being here.
Righty, so we're right on time and I think we're all set.